A good Vach Shavua Tov. A good evening to everybody. Starting off the week beautifully with some learning on a Saturday night. Let's light up the darkness. Who's in the house on a Saturday night? Carla in Brazil, Sharon in New Jersey, it skipped on me, Bill in mid-Missouri, Bella in Florida, Joe in the Inland Empire, Melissa in Great Neck, right? It keeps skipping on me. Where'd you go, Melissa? Where did you go? Paul in the Great Northwest, Shandora in the Bronx, Joe in the Inland Empire, Melissa in Great Neck, Paula in Chicago, Charles in Omaha. Ella says, Shalom, welcome everybody. It's great to be learning with you. Tonight's episode of AT Daily, sponsored by John Kolodgy. Doesn't say in honor, memory, or healing. So let's just say in honor of Franciscus Kolodzey and Maria Pekar. I'm getting the feeling, John, that you share my Hungarian background because these sound a little bit like Hungarian names to me, but maybe I'm mistaken. At any rate, John, may all your loved ones be showered in blessings. Thank you for enabling us to share more Torah with more people around the world. And we all say Amen. An extra love for you and for Franciscus and Maria. If this is in memory of, may the neshamas have a great aliyah. And if, this is in honor of, may they and all your family live to 120. We say amen. All right. Let's get to it. Our daf is page 44. We're in chapter 4 of Tractate Bava Kamma, the 21st volume of the Talmud. Today, finishing Mishna number 5 in chapter 4, and then we're going to cover Mishna number 6. That's a short Mishna, and Mishna number 7, another short Mishna, which God willing will complete tonight as well. So, the Mishnah teaches, our Mishnah number 5, that, and the same law applies in a case where the ox killed a boy or in a case where the ox killed a girl. Remember that the ox is put down if it kills a human. And the sages taught, the verse states, whether it has gored a son or has gored a daughter. Exodus 21:31. To deem the owner liable for the death of minors, just as for adults. So the Baraisa asks, and could this not be derived through logical inference? Since the Torah renders a person liable to receive court-imposed capital punishment for killing another person, and similarly renders an ox liable to be killed for killing a person, it should be derived that just as when the Torah renders a person liable for killing a person, and the Torah makes no distinction with whether the victim was a minor or an adult, so too, when it renders the ox liable for killing a person, it should not differentiate with regard to minors and adults. So why did the Torah feel the need to specify that the ox is put down whether it killed a boy or a girl after saying whether it killed a person? And furthermore, we could have derived the same idea not through a logical inference, but rather through a kal v'chomer inference, also known as a fortiori inference, like this. If, in the case of a person killing a person, the Torah does not render minors entirely like adults with regard to this act, inasmuch as minors are exempt from liability for killing, right? Doesn't mean that there's no punishment or consequences, but it does mean that a minor who's considered not halakhically competent, not legally competent, is not subject to the death penalty for committing murder. But nevertheless, it renders a person liable for killing minors as well as adults. Then, now we're in 44a, in the case of an ox killing a person, where the Torah renders small oxen just like large ones with regard to this act, as a young calf that kills a person is killed, put down, just as an adult ox that kills a person, is it not logical that the Torah renders it liable for killing minors, i.e. a boy or a girl, just as for killing adults? Therefore, since we could have derived this either through the logical inference or through the kal v'chomer inference, why was it necessary for the Torah to include a verse to teach us this principle? And now what the Gemara is going to do, and this is such good training for all of us as logical thinkers, and this is why Talmud study is both so difficult and so rewarding. Right, what the Gemara is now going to show is that, well, that sounded good. The logic that you just gave me sounded good. And the kal v'chomer inference that you gave me sounded good. But actually, we can disrupt it, right? We can show that it is unsound, unfounded, right? So the Gemara rejects this claim. No, this cannot be derived by logic alone. If you say that a person who kills a person is liable even when the victim is a minor, well, this may be due to the extra severity in the case of a human assailant, right? A human has extra stringencies on him in the sense that we've already talked about. For example, the difference between a tam and a muad, right? An ox that is a tam that doesn't have a history of goring is considered a different category than an ox that has a history of goring. And so if the habitual gorer, known as the muad, gores somebody, different consequences ensue than if the innocuous ox, the one without the history of goring, gores an animal or a person. But a human who has agency over himself or herself is always considered forewarned. And whatever the consequences are, it doesn't matter that you didn't do it before. If you commit murder, even though it's your first murder, you're subject to the death penalty. So, if you say that a person who kills a person is liable even when the victim is a minor, this may be due to the extra severity in the case of a human assailant. And another difference than the one I just named is that a human assailant, right, when a human commits violence on another human, he is liable to pay 4 types of indemnity for causing injury, namely pain, humiliation, medical costs, and loss of livelihood, in addition to payment for the actual damage. Shall you also say that this is the law with regard to an ox, whose owner is not liable to pay these 4 types of indemnity? When your ox gores another person, you pay for the damage that the ox caused, but not for pain, humiliation, loss of livelihood, medical. Clearly, this law cannot be derived merely through logical comparison between the 2 cases. Therefore, the verse states, whether it has gored a son or has gored a daughter, to render it liable for minors as well as adults. And I have derived this law only with regard to forewarned oxen, the muad, the habitual gorer. From where do I derive that in the case of an innocuous ox, it is killed also if it kills a boy or a girl? And the Baraisa asks, could this not be derived through logical inference? Since the Torah renders an ox liable to be killed for killing a man or a woman, and likewise renders it liable to be killed for killing a boy or a girl, then just as when it renders it liable to be killed for killing a man or a woman, you do not differentiate between the innocuous or the forewarned ox, as both of them are stoned, so too, when it renders an ox liable to be killing for killing a boy or a girl, do not differentiate between an innocuous ox and a forewarned ox. And furthermore, we could have derived it, instead of through the logical inference, we could have derived it through the kal v'chomer inference like this. If, with regard to a man or a woman whose power is diminished with regard to damages, what do we mean by power is diminished? Keep listening. Whose power is diminished with regard to damages, because adults who cause damage are liable to pay. But nevertheless, you do not differentiate between an innocuous ox and a forewarned ox that kills them. Then, with regard to a boy or a girl whose power is enhanced with regard to damages, because they are not liable to pay for damage when they cause damage, is it not logical that you should not differentiate between an innocuous ox and a forewarned ox that kills them? When I hear that one, I'm like, well, wait a minute. We're talking about we're gonna say that because when they act as the aggressor, an adult is liable, but a child is not. When we now speak of the child or the adult as the victim, we're going to draw out a logical inference or a kal v'chomer inference. And I say, well, no, that doesn't really work because you're comparing apples and oranges. And indeed, the Gemara will reject that. And so the Baraisa answers that you could say in response, but does one derive the law of a lenient matter from a stringent matter in order to be more stringent with regard to it? If the Torah is stringent with regard to the case of a forewarned ox, which is a stringent matter, rendering it liable to be killed for killing a minor, does that mean that you should be stringent with regard to an innocuous ox, which is a relatively lenient matter? And furthermore, there is another reason to reject the earlier opinion. If you say that an innocuous ox is liable to kill for killing a man or a woman, as they are obligated in the mitzvahs, right? Adults are obligated in the mitzvahs, children are not, and that gives them importance. Does that mean that you should say the same with regard to a child, a boy or a girl, who are exempt from the mitzvahs? Since the law could not have been derived through logic alone, that's why the verse states whether it has gored a son or it has gored a daughter. And stating the phrase gored twice teaches you that it is referring both to the goring of an innocuous ox and the goring of a forewarned ox. And also you learn from it that this is both with regard to the goring that causes death and the goring that causes injury. In all these cases, the owner of the ox is liable, even if the ox gores a minor. And that concludes our discussion of Mishnah number 5 here in chapter 4. Here's Mishnah number 6. If an ox was rubbing against a wall, and as a result, the wall fell on a person and killed him, kill another animal, but killed a person, or if the ox intended to kill a Canaanite, but instead killed a Jew, or intended to kill a non-viable baby, but instead killed a viable person, in all these cases, the ox is exempt from being killed because it did not have, even an ox has intent, right? If it gores something, it intends to kill, right? And if it gores, if you somehow can see that it intended to gore something or someone for which the death penalty would not apply, and it ended up killing something or someone for which the death penalty would apply, the death penalty of an ox, but its intent was in a non-death penalty situation, non-stoning situation, then the stoning will not apply. So intent matters even with respect to what the ox was intending to do. How much more does intent matter for a person? That's the Gemara. That's the Mishnah. Here's the Gemara. Shmuel says the ox is exempt from being put to death since it did not intend to kill. But its owner is liable to pay ransom if a human was killed. And Rav says they are exempt from this liability and that liability. That's very interesting. If the ox didn't intend to kill a person but ends up killing a person, it isn't put down in that situation because it wasn't, a vicious attacking ox that wanted to kill and killed. It was some kind of weird circumstance. So even though a person ended up dying, the minority view seems to be, we don't know yet about where we are in terms of the ransom. What we're saying in the Mishnah is that the ox is not put down. Now Shmuel says, no, you're not put down, but you are liable for the ransom. And Rav says exempt from this liability and from that liability. And actually, I'm pretty sure the law follows Shmuel because it's a monetary matter. Do we get this? So where the law ended up, if an ox rubbed against a wall for pleasure, as it was seen rubbing against it even after the wall fell, and the wall collapsed on top of a person and he died, the ox is not liable to be stoned since it has no intention to kill the person. If the ox was forewarned with regard to rubbing against walls and causing them to collapse, the owner must pay the ransom in accordance with the opinion of Shmuel, whose opinion is followed in matters of monetary law. So there you go. Okay. So the Gemara asks about Shmuel's opinion. And why is he liable to pay ransom? Isn't the ox innocuous with regard to this action? The Gemara answers, as Rav says in a different context, it is referring to an ox that was forewarned with regard to falling on people in pits. It has a history of doing that. So here too, it is referring to an ox that was forewarned with regard to rubbing against walls and causing them to fall on people. Somehow this ox has figured out that it can hurt people by rubbing against walls and get away with it. Obviously, this is probably in the realm of hypothetical cases to test our understanding of the law. So the Gemara asks, if it was forewarned with regard to this behavior, it clearly intended to kill the person and is therefore subject to being put to death, contrary to the ruling in our Mishnah, which says it didn't have that intent. So the Gemara explains, granted, there in the case where the ox was forewarned with regard to falling on people in pits, it could be that it saw a vegetable on the edge of the pit and subsequently fell in without any intention to kill. But here, where it rubbed against a wall, causing it to fall on a person, and was forewarned with regard to this behavior, what is there to say in the ox's defense? And the Gemara answers, here also the case is where the ox rubbed against the wall for its pleasure and not in order to kill. So the Gemara asks, and from where do we know that it did not intend to kill? The Gemara answers, because even after the wall fell, it was still rubbing against it, which proves that this was its intention. It didn't mean to hurt anybody. It had an itch. It was rubbing against the wall. It caused an accident. It didn't do that before. Even possibly if it did it before and caused the wall to fall and people got hurt, we're not sure that we're going to render this death penalty offense for the ox, but certainly not the first time, and that's why the Mishnah says we don't put down the ox in that situation. The question is, does the owner of the ox have to pay the ransom now that a person died? Now we're on 44b. And the Gemara asks, but still, is this not a case of pebbles? Right? Remember, we talked about pebbles when we were talking about the kind of damage that an ox causes via trampling. Right? So trampling is just an ox walking in the ordinary course of things, and it walks over something. Right? So there's no liability if that happens in the public domain, but there is liability if it happens on somebody else's property, that your ox walks over something. Now, no liability in the public domain, but if the ox is kicking up pebbles and those pebbles break some vessels, at least according to some opinions in some situations, the owner is liable to pay half damages, like the case of an innocuous ox that gores. So now this idea of rubbing itself against a wall and the wall falls down and hurts somebody is being compared to the case of pebbles. Is this case not analogous to damage caused by pebbles inadvertently propelled from under the feet of an animal while it is walking, which is not considered damage caused directly by the ox, but rather damage that is caused indirectly? Ransom is not imposed for such indirect damage, even if it results in the death of a person. So Rav Mari, the son of Rav Kahana, said, it is a case where the wall gradually gave way under the pressure applied by the ox. And so while the ox was still pushing the wall, it collapsed and killed a person. Now, it is taught in a Baraisa in accordance with the opinion of Shmuel, and this Baraisa is a conclusive refutation of the opinion of Rab. Says the Baraisa, there are cases where the ox is liable to be put to death and the owner is liable to pay the ransom, right? A goring of a habitual gorer gores a person and the person dies. For sure, you put down the ox, for sure the owner has to pay the ransom. But there are also cases where the owner is liable to pay ransom, but the ox is exempt from being put to death. We have to see how that is. And there are cases where the ox is liable to be put to death, but the owner is exempt from paying the ransom. And there are cases where the ox is exempt from being put down, and the owner is exempt from paying the ransom. How so? In a case where a forewarned ox kills a person intentionally, the ox is liable to be put to death and the owner is liable to pay the ransom. If a forewarned ox kills unintentionally, the owner is liable to pay ransom, but the ox is exempt from being put to death. Right? The ox was not acting at that moment to hurt somebody, but because it was a forewarned ox that ended up killing a person, and the owner should have used extra caution with such a forewarned ox, he becomes liable to pay the ransom. Even though the ox is not put down in that situation because the ox wasn't intending to gore somebody. If an innocuous ox kills intentionally, so the ox is liable to be put to death, but the owner is exempt from paying the ransom. And if an innocuous ox kills unintentionally, the ox is exempt from being stoned, and the owner is exempt from paying the ransom. So the Baraisa states explicitly that although a forewarned ox that kills a person unintentionally is exempt from being put to death, the owner is liable to pay the ransom. And this is in accordance with Shmuel's opinion and in contrast with Rab's opinion. So the Baraisa adds, and for injuries caused by an ox unintentionally from which the victim is not killed, Rabbi Yehuda deems the owner liable to pay for the injury, and Rabbi Shimon exempts him. And the Gemara asks, what is the reason for the opinion of Rabbi Yehuda? And the Gemara answers, he derives the law with regard to injury caused by the ox from the law with regard to its owner's ransom payment. So just as with regard to its owner's ransom payment, he is liable even if the ox gores unintentionally, so too with regard to injuries, he is liable even if it gores unintentionally. And Rabbi Shimon derives his opinion from the law of the putting to death of an ox by the court. Just as with regard to the ox being put to death, if it kills a person unintentionally, it is exempt. So too, if it injures unintentionally, its owner is exempt from payment. So the Gemara questions this explanation. And let Rabbi Yehuda also derive the law concerning an ox unintentionally causing injury from the law of its being put to death. And the Gemara answers, in his opinion, we can derive a law with regard to payment for injury from the law of ransom, which is another law with regard to paying money. But we cannot derive a law with regard to payment from a law concerning death, the death of the ox when it's put down. Conversely, the Gemara asks, okay, so then let Rabbi Shimon also derive the law from the law concerning the owner's ransom payment. And the Gemara answers, we can derive a law with regard to the liability of an ox from a law with regard to the liability of an ox to the exclusion of the payment of ransom, which is not a liability of the ox, but rather a liability of its owner, right? When the ox causes damage, that's considered the liability of the ox, right? And if it's an innocuous ox, the injured party only has recourse to the body of the ox. When we're talking, and even a forewarned ox that causes damage, there's the liability for that damage we can take from the owner's property, but that's really regarding liability of the ox, right? As opposed to ransom, because even if he has to pay damages, with regard to the ransom, that is an atonement for him. That's why the ransom is in addition to the damages. And what Rabbi Shimon is saying, so what we would say here is that what Rabbi Shimon would say is that when we're talking about liability of the ox, we can, compare laws. But we're not going to compare that law to the law of ransom, because the law of ransom has to do with an atonement for the owner, not for the damage caused by the ox. The Mishnah teaches that if an ox intended to kill another animal, but it killed a person, or if it intended to kill a person for whom it would not be liable to be put to death, but it killed a person for whom it would be liable, it is exempt. And the Gemara infers, if the ox intended to kill this person for whom it would be liable, but it killed that person instead, it is still liable. Accordingly, the Mishnah is not in accordance with the opinion of Rabbi Shimon, as it is taught in a Baraisa that Rabbi Shimon says, even if the ox intended to kill this person but ended up killing that person, it is exempt. And the Gemara asks, what is the reason for the opinion of Rabbi Shimon? And the Gemara answers that it is because the verse states, the ox shall be stoned, and its owner also shall be put to death. And the juxtaposition of the ox and its owner indicates that as the death of the owner, i.e. a person, for killing another person, so is the death of the ox for killing a person. In other words, the two laws are applied in the same circumstances. Specifically, just as the owner, i.e. a person, is not liable to receive court-imposed capital punishment unless he intends to kill the person whom he ultimately kills, so too an ox is not put to death either unless it intends to kill the one whom it ultimately kills. Now, this is very interesting. If, I guess you would say something like, somebody comes to attack me, and it's dark, right? And, I'm in fear of my life, and I take out my gun and shoot at him, right, intending to kill him. And instead, I kill, somebody else. Now, that's an accident. That's a tragic accident. And it's pretty obvious that I wouldn't be liable to the death penalty for killing that other person accidentally. What if I'm in a, crime of passion, and for some reason I go crazy, and somebody insulted me and I decide I'm going to kill him, and I try to kill him, and now accidentally I kill someone else. So now you could say, well, I was trying to commit murder, so the wrong person died. I should still be guilty of murder, right? But apparently not, because unless you end up killing the person you intended to kill, it's not that you're not guilty of murder. The question is, are we going to apply the death penalty? Right? Are we going to apply the death penalty there? And this is why now we've got to back up a little bit and understand that in this whole discussion, when we're talking about the court assigning the death penalty to a situation, the sages are going to make that incredibly difficult. And that's why we learn in Tractate Sanhedrin, a court that executes once in 70 years is a murderous court. Right? The sages are very, very reticent to apply a death penalty. Is there going to be other punishment? Oh, yeah. Is there going to be a parallel legal system? Almost certainly. I mean, first of all, like where the only law of the land is the Torah? Certainly not in modern Israel. Modern Israel has its own legal system that at times is very much at odds with Torah law. So, any time that the Jews, even if they're living in the Holy Land but don't have sovereignty over the Holy Land, there's a whole other legal system. You could say, well, what about in the early days when Joshua first led the children of Israel into the Holy Land? Okay, then they must have been living with Torah law as the only source of law. I'm not sure. I'm not even sure if that's true. There were municipal codes. Before there were kings, right? Saul was the first king. That's 400 years after Joshua leads the children of Israel into the land. I'm not sure that people were living just according to Torah law, even in that period, right? So what we're talking about when we're talking about, assigning the death penalty or not, you got to be very careful, how we understand this. Generally, here in the Talmud, what we're just talking about is, according to a particular Torah verse, is capital punishment applicable or not? Was it actually applied? Was there another legal system? Were we actually living under the authority of some foreign power, whether it was Rome or Greece or Babylonia, all the different empires that had power over the Holy Land, or all the different nations in the diaspora where Jews live? Obviously, we're always subject to the law of the land. And in fact, that is a Torah, it's a rabbinic ordinance, right? That the law of the land is the law, right? So a Jew has to follow the laws of the land that he lives in according to Torah law. The law of the land is the law. The only exception being where the law of the land is in direct conflict with the Torah law. Then you shouldn't live in that country, right? That's a problem. Okay, so let's go on in keeping that context in mind. The Gemara asks, and with regard to the owner himself, from where do we derive that he is not liable unless he killed the one whom he intended to kill? Well, this is as the verse states, Deuteronomy 19:11. And he lay in wait for him and rose against him and struck him mortally, and he died. So from the term for him, Rabbi Shimon derives that the killer is not liable unless he intends to kill him, the one who ultimately died. And the Gemara asks, and what do the rabbis who deem the killer liable in that case, and who therefore disagree with Rabbi Shimon's opinion, what do they do with this phrase, and he lay in wait for him? How do they interpret it? And the Gemara answers that the sages of the school of Rabbi Yanai say that this phrase excludes from liability one who throws a stone into an area where there are several people, some of whom are people for whom he would not be liable to receive court-imposed capital punishment, for example, Canaanites, and a stone he threw it there where there are people that he's not liable to the death penalty, like Canaanites. And there's other people for whom he would be liable for the death penalty, which include Jews and presumably the ger toshav, the resident alien. And a stone killed a person for whom he would receive a court-imposed capital punishment. So the Gemara asks, what are the circumstances of this case? If we say that there are 9 Canaanites in the crowd and 1 Jew among them, even without the verse, we can derive the exemption from the fact that a majority of them are Canaanites. Alternatively, even if half the people are Canaanites and half are Jews, derive the exemption from the principle that when there is uncertainty concerning capital law, the law is to be lenient. Again, they're just not going to impose the death penalty, even in these hypothetical cases, unless everything lines up with the law as stated in the Torah. If there's any out, they're going to take the out and not impose the death penalty. So the Gemara answers, well, no, the verse is necessary in a case where there are 9 Jews and 1 Canaanite. Although a majority of them are Jews, the thrower is exempt from liability because there is 1 Canaanite among them who is considered fixed in his place, and the legal status of any item fixed in its place is like that of an uncertainty that is equally balanced. And when there is uncertainty concerning capital law, the law is to be lenient. And this is what the rabbis derive from the phrase, and he lay in wait for him. Now you see, if you don't understand, context, that's a loaded word these days. But this is the kind of passage that anti-Semites will say, oh, well, your Talmud says that you value Jewish life more than non-Jewish life. If you're saying that, you don't understand what we just read. Because what this is all about is finding an out to not apply the death penalty, right? There's also other matters that are involved here, which is, when we're talking about the jurisdiction of a rabbinic court, it's only going to apply to people who submit to the jurisdiction of a rabbinic court. And that's why we've seen at other times in our discussion that the ger toshav, right? Now, when we're talking just about when Jews have sovereignty in the land, in the Holy Land, that there's a distinction made between the ger toshav, the non-Jew who lives in that land and submits to the authority of the sages and of Torah law and accepts upon himself to live by the 7 Noahide laws. That person is a completely different category than one who does not submit himself to the 7 Noahide laws. Because frankly, somebody who won't live by the 7 Noahide laws, that's a barbarian, right? That's somebody who won't accept that he can't rape, that he can't murder, that he can't steal. You could say, he's not quite in that same category, that he also doesn't accept that there is one God. But if you're going to live in Israel, when Jews have sovereignty there, then you have to submit to the Noahide laws. Really not that hard to do. You just don't have to curse God. You don't have to, blaspheme God. You just stay silent. And on those issues, and not murder, not rape, not steal, not tear a limb from a living animal, and establish courts of law, right? Which is different than the rabbinic court. So it's very interesting. There's just a lot of, somebody who won't do that, then you're really talking about some kind of a barbarian, and that is considered a different category. Okay, that concludes our discussion of Mishnah number 6. Here comes Mishnah number 7. With regard to an ox belonging to a woman, and similarly an ox belonging to orphans, and an ox belonging to orphans that is in the custody of their steward, and a desert ox, which means a wild ox that is ownerless, and an ox that was consecrated to the temple treasury, and an ox belonging to a convert who died and he has no heirs, rendering the ox ownerless. In all of these cases, the oxen are nevertheless liable to be put to death for killing a person. That's what we would want. You would say, you might say, since the ox has no owner, and it had no legal owner, no legal capacity, to pay the ransom, perhaps if such an ox kills people, then the ox also is exempt from the death penalty, to be put down by stoning. But no, the ox that kills people, even if it is ownerless or doesn't have a legally competent owner, not one who can pay the ransom, nevertheless, the ox is put down. Rabbi Yehuda says, a desert ox, a consecrated ox, an ox belonging to a convert who died, and therefore is ownerless, are exempt from being put to death because they have no owners. Rabbi Yehuda lost that battle. He's in the minority. The sages, here's the Gemara. The sages taught in the passage discussing an ox that kills a person, Exodus 21, verses 28 through 32, the Torah states, an ox. And the word an ox, repeating this, is repeated 7 times. And it's repeated 7 times to include an additional 6 cases, in addition to the classic case of an ox goring and killing a person. What are these 6 cases that are added? The ox belonging to a woman, an ox belonging to orphans, an ox belonging to orphans that is in the custody of a steward, a desert ox, a consecrated ox, an ox belonging to a convert who died and has no heirs. Rabbi Yehuda says a desert ox, a consecrated ox, and an ox belonging to a convert who died and has no heirs are all exempt from being put to death because they have no owners, unlike the one with a steward or owned by a woman. Rav Huna says Rabbi Yehuda would deem the ox exempt even if it gored and killed and its owner ultimately consecrated it, or if it gored and he ultimately renounced his ownership over it, since at the time of the trial in court, the ox does not have an owner. It had an owner when it gored, but by the time it's gonna, witnesses are gonna testify that this ox killed a person, and now the court's gonna say the ox needs to be stoned, but at that time, the ox has already been renounced. Like the owner doesn't own it anymore. That could actually save the life of the ox. At least Rabbi Yehuda, according to Rabbi Yehuda. So the Gemara asks, from where did Rav Huna derive this assertion? From the fact that Rabbi Yehuda teaches 2 cases, a desert ox and an ox belonging to a convert who died and has no heirs. What is the legal status of an ox that belonged to a convert who died? Since he has no heirs, it is considered to be an ownerless ox. Accordingly, the case of a desert ox is the same as the case of an ox belonging to a convert who died and left no heirs. And it does not seem necessary for the Baraisa to teach both cases. Rather, does it not teach us this, that even if the ox gored and then the owner consecrated it, or if the ox gored and the owner ultimately renounced ownership over it, it is exempt, just as in a case where a convert's ox gores and subsequently the owner dies. And the Gemara conclude from the Baraisa that this is the opinion of Rabbi Yehuda, but it is not the law. Okay, I'm almost done. Questions or comments, please get them in. Now, this assertion is also taught in a baraisa. Moreover, Rabbi Yehuda said that even if it gored and he ultimately consecrated it, or it gored and he ultimately renounced ownership over it, the ox is exempt, as it is stated, and warning has been given to the owner, and it killed, the ox shall be stoned. It is derived from here that the owner of the ox is exempt unless the ox's status as the owner's property at the time of the death of the victim and at the time of the owner's standing trial is the same, i.e. that the ox has an owner, both when it killed somebody and when it stood trial. And the Gemara asks, but don't we require that the ox's status be the same at the time of the verdict as well? In other words, if the judges presided over the trial and heard witness testimony and there was still an owner, and then the guy says, you know what, I'm going to lose this case, and then he renounces ownership of the ox, that still would get the ox off from the death penalty, according to Rabbi Yehuda. And the Gemara asks, but don't we require that the ox's status be the same at the time of the verdict as well? And isn't the phrase, the ox shall be stoned, also referring to the verdict? Rather, amend the statement and say that the owner of the ox is exempt unless the ox's status as the owner's property at the time of the death of the victim and at the time of the owner's standing trial and at the time of the verdict are identical as one. And that's all according to Rabbi Yehuda's opinion. That's where we'll knock off for tonight. And God willing, tomorrow at the regular time, 6 p.m. Pacific, we'll continue with Mishnah number 8 here in chapter 4. All right, let's take a couple of questions on Bava Kamma 44. Sharon says, I cannot believe that an ox can discriminate between a Jew and a Canaanite. I don't think that it needs to. I think it just simply means that it intended to kill one person, like it was chasing somebody, and then it swerved, right, while it was running, and it ended up killing someone else, right? And the one that it was running after would not have resulted in the death penalty, and the one that it killed would have, but in this case, the death penalty is not applied. Alice, do you interrogate an ox? How do you know how much it understands? He might be a stubborn ox and not answer. Very good. I think, obviously you don't interrogate the ox. I think what they're saying is from the circumstances, we can see what the ox was trying to do, right? Just like if it's rubbing its, skin against a wall, it's not trying to hurt somebody. It's just trying to scratch an itch. If the wall happens to fall, then you could say that ox was not intending to kill someone, even though the stones ended up falling and hurting someone. But what they were saying is, well, maybe we could find a case where the ox knows there's someone on the other side of the wall, and it, shoves the wall and it hurts a person. And you might say it was trying to scratch an itch, but if it does that, a few times, then we're like, oh yeah, this ox has figured out how to kill people by pushing walls over. Bill, it's probably the case that during the tribal Republican period, that is between Joshua and Saul, there almost certainly were local laws that had a relationship to the Torah, but were not per se Torah laws. The judges probably ruled at their best by Torah law, but we have to remember the office of the shafet, the judge, was a sort of emergency power. They were appointed by God ad hoc when the people in Israel needed a single, mostly military leader. Although now I've said that, I've talked myself around. Even the judges may not have ruled by Torah law alone. As semi-military leaders, the judges would almost certainly have had military justice, which would probably be a bit more willing to shed blood than the sages. Exactly. But there's always these parallel legal systems that are in place. One would be military law. I mean, what I find fascinating is when we talk about the cities of refuge, right? So when the law of the cities of refuge is that the manslaughterer, one who did not lie in wait, but one, who was swinging his axe, and maybe he was negligent. It wasn't totally circumstances that had nothing to do with him. That he was swinging an axe, but he was just trying to chop a tree. Maybe he was negligent, but on the backswing, he hit somebody in the head, or the axe head flew off the handle, and it killed someone. Right? So this is the situation where the Torah establishes cities of refuge, where the person can go and be exiled to the city of refuge, And, it might be 1 year, it might be 50 years, right? For as long as the current high priest is alive. And when the current high priest dies, he can return home. Why was he exiled to the city of refuge? Says the Torah, because in the city of refuge, the avenger of blood may not go and avenge the death. Who's the avenger of blood? Presumably a family member who is going to, take matters in hand and, basically prosecute a blood feud because, this negligent person, killed my relative. I'm going to go kill the negligent person. That's what the avenger of blood is. But the Torah doesn't specify, the practices and procedures of what avengers of blood can and can't do, other than that they can't enter the city of refuge, to kill this. So it seems like that it shows that there was a whole system in place, that existed at that time that the Torah came to modify and modulate, what avengers of blood could and couldn't do. But the Torah doesn't spell out what the avengers of blood could and couldn't do other than that. So there's clearly other laws that were in place. So when you're talking about the authority of a rabbinic court, that's purely by Torah law. But were matters settled between parties outside of a rabbinic court? All the time. And we see that is so when they were talking about, the court will seize an ox or not seize an ox to pay damages. But if the injured party has already seized the ox, the court will not undo that unless there's a strong reason to do it. Right? So again, it was not such a litigious society like ours is. I think justice was, settled many times outside the courtroom. And what the sages are talking about is what the rabbinic court can and can't do, what it can rule and what it cannot rule. And in some ways, it was like, it's not the same. It's not the same at all. I don't want to use this metaphor to tell you go, oh, Sal said it was like arbitration. It's not like arbitration, but in some ways, the society function that way in the sense that not everybody went to the rabbinic court. Not everybody was brought to a rabbinic court. What the sages are talking about in their deliberations is what a rabbinic court can and can't do. Sharon says, if an ox is wild, then our premise that it is a neutered bull is not applicable, is it? Absolutely not. Right? Absolutely not. Wait, who said neutered bull? I don't think that is our premise. Right? We don't castrate animals. I think I don't know where we got that premise. We talked about that a little bit before. I have not done further research on that. I do not believe that when we're talking about an ox, we're talking about a neutered bull. I think that that's just being used. I mean, maybe I don't know. I just need to do further research on that. I guess a good question would be, is there a, male cow that will submit to the plow if it still, has its sexuality in place? I don't know the answer to that. And Melly says, what if after the ox was taken and it just tried to get back home? I think you're suggesting that there's, we could be seeing, you mean like the owner declares it ownerless? Not my ox, and then the ox comes back home, then what do we do? Well, that's an interesting question because something that is ownerless can be claimed. It can be acquired. So can an owner of an ox that gored, even a muad ox, declare it ownerless? Okay, I don't want to deal with this. I don't want to pay damages. I don't want to pay ransom. I don't want the ox to be put down. I give up ownership of the ox. And then the ox comes back to his house. Can he now reclaim the ox and avoid the damages? That's a great question, and I don't know the answer. That's what I've got for us tonight, and with God's help, we'll be together again tomorrow night at 6 p.m. Pacific. See you then.